Hey everyone, it's Rob Ryder on Sunday, November 10th, 2013. Today we're going to talk about the use, later called the trust, and the courts. And this will be including common law's dirty little secret. They really don't want you to know this. If you can donate, please. The PayPal account name is ashleyritluski@gmail.com. That is the PayPal account name. And snail mail is Robert Ritluski, 10955 14 Mile Road, Rockford, Michigan, 49341. I want to thank everybody who has donated. I was able to pay my rent. Thank you very much. Took care of my cable bill. Thank you, thank you. Thank you, Handcuff John. You came through big time at the exact right time, as did everybody else. So, enough said. Thank you again. Let's see if I can repay in some way, someday. You find something that I say to be useful to you. So let's look at a little history. Always got to start with the history, right? None of this shit happened last week. It didn't happen in 1933. It didn't happen whenever. It's common law. Goes back a long way. Let's see what we got here. Trust is an expectation that others... before I start, how am I going to do this so that you can find these later? Here's a good thing. A lot of these things I find on PDFs online, right? So I'm just going to show you the names. Stop the video, write the name down, Google it, and you can find it. In case you don't get a copy of it because you're not on my email address list, you're not getting the documents that come through, and my email is Court of Record. Write this down if you don't have it. Court of Record, COURTOFRECORD, Court of Record @AOL.com. Send me an email, put add to email list, and I will. And when I do a video from now on and have documents that I'm sending along with it, you'll get them. But let's look at what some of these are, and just stop the tape for a second, write the name down. If you really want to have a copy of it and didn't get it, great. So, first, trust and fiduciary duty in the early common law. David J. Seip, S-E-I-P-P. If you were to put that much information into Google, you'll find this document. I'm sure of it. So that's one of them we're going to be using. The history of probate courts. Let's see what this is. The history of probate court. Stop the tape. Write it down. Eugene A. Hartel, H-A-E-R-T-L-E. From the Marquette Law Review. And what else we got? This is the overview of probate court jurisdiction. I think that was the name. This is something particular in Michigan, and as you can see, it didn't have a cover sheet. Overview of probate court jurisdiction, Michigan. Interesting stuff in it, though. Overview of probate court jurisdiction. And this is a little flyer out of Georgia. Georgia Probate Courts, presented as a public service by Probate Court of Bibb County. There you go. And one more, I think. Now, Jurisdiction of the Probate Courts of Illinois by Cecil Bronston. B-R-O-N-S-T-O-N. Cecil Bronston. 10/2/2013. They just recently put this one online. Interesting. And I don't think I use this one. What is this one here? Oh, the debate over non-lawyer probate judges, a historical perspective. Didn't really put much in, but it is interesting reading. The debate of non-lawyer probate judges, a historical perspective. Okay, so out of those, I cut and paste parts out, put them into words because I like to color. And so here we are. So a trust is an expectation that others will act in one's own interest. Trusts are also a specialized meaning in Anglo-American law denoting an arrangement, which is an agreement, by which land or other property is managed by one party, a trustee, on behalf of another party, a beneficiary. Right? So Now that's two of the parties involved, right? But who's the one who gave the property to the trustee? Well, that would be the trustor or grantor. Settlor, though the ors are the ones who put it in. The e's are the ones that watch it, and the beneficiary is the one who's supposed to get the enjoyment of it. Fiduciary duties are duties enforced by law and imposed on persons in certain relationships, requiring them to act entirely in the interest of another, a beneficiary, and not in their own interest. Common law, the law applied in England's central royal courts, was the dominant feature of this legal system. The long understood story is that English common law in its formative centuries was unacquainted with trust as a legal device or as a human practice. They didn't know anything about trust. They didn't trust each other. And the fiduciary duties grew up outside of the common law in a separate court of chancery, which was actually, prior to that, just the church courts. Eventually became the court of chancery, with the law of trust and trustees, only being incorporated a century and a half ago with the fusion of law and equity. In Michigan, 1848, I believe it was, we got rid of the courts of chancery. Their duties were absorbed by the court of the circuit court. So the circuit court was the common law court, and now it was the common law and equity court. And so when you go to court today, an attorney will tell you you're going into a court of equity. It can be, because they have both powers. It's just depending on how they're going to use them against you. Because the whole idea of the courts is to take your property, right? If there wasn't a controversy created by somebody, you wouldn't be there in the first place. So it's a place for controversies to be settled, and so the courts are set up for the guy bringing the controversy to win. Otherwise, people wouldn't go to court. Trusts were enforced by chancery, a court of equity, not by courts of common law. Fiduciary duties and law trusts thus seem to have grown up outside of the common law, in a different court that developed later than the common law courts, and was something regarded as their adversary or rival. So the court of chancery was an adversary to the courts of common law, courts of equity compared to courts of common law. Two different forms of law. Because the common law did not enforce the trust, nor their predecessors called uses, it's sometimes thought that uses and trusts were invisible to the common law. In particular, this argument was made in 1526 to 1535, after they had been used for 300 years, that all of a sudden they were fraud or collusion. Well, why was that? Well, it's because Henry VIII wanted more money. Okay, so this is in honor of some Yahoo. And so judges in the common law, they wrote extensively about uses, and they identified trust as an essence of their arrangements. All right, so they wrote extensively about uses. That's the procedure or the instrument or whatever. And they identified trust as the essence of these arrangements. So the arrangement was the use, and the essence was the trust between the grantor and the trustee. Rigor of the common law. Now pay attention. Early, because this ain't changed. Early English common law, because the common law doesn't change. Common law is the common law. Early English common law acquired a reputation for rigor, for uniform application of rules, even in harsh circumstances that would seem to beg for exceptions. In other words, it's all about following the rule, has nothing to do about who's right. Those who knew the rules well could use them in their advantage, and those who lost out thereby were told by common law judges that it was their own folly, that they had not protected themselves. You come into my court of common law and you don't know the rules, it doesn't matter if you're right or wrong, you're going to lose. In part, the Chancellor's jurisdiction of equity developed in order to mitigate the harshness of the common law rules. Right, because in common law, he who has the legal title is the owner. It doesn't matter how he got it. He could steal it from your safe in the middle of the night. If he can walk out in court with the legal title, he's the owner. you don't have a snowball's chance in hell unless you're going to go to the chancellor, and the chancellor's court of equity would get you your remedy. But the court of common law says he who has the legal title is the owner, and they don't care how they got it. This is also why fiduciary duties, which became so closely linked to the chancellor's jurisdiction over trust, can be thought to be contrary to the spirit of early common law, right? So, go figure. Fiduciary duties, being responsible for something, is actually contrary to the spirit of common law. Here are some examples of common law rules that seem to embody what might be called anti-fiduciary impulse or hostility to trusting and fiduciary duties or fiduciary relationships. In early contract law, if I became your debtor by a written, signed, and sealed promise to pay, and then I fully repaid the debt to you, I would trust that you would destroy the bond, cancel it, or give me a written release. Right? I would trust you to destroy the bond, cancel it, or give me a written release. If you instead did none of these, you could then sue me in the king's court on the original debt, and my evidence of full repayment would not be received. Those are the rules of common law. So if I didn't see you destroy it, cancel it, or give me a release, if I didn't have those things, you could take that damn bond, go back into court and say I hadn't paid you, even though I could have 10 people walk in and say that I did. Wouldn't matter. Only outside the common law, in the equity court of the chancellor, could I prove my repayment. That's why we got to find the correct courts and enjoin my creditor from suing me at common law for a second repayment of my debt. If I dispensed with the formalities of sealing the writing and I became your debtor by a solemn oral promise to pay and a handshake, you would trust me to keep my oral promise. But if I then refused to pay, the common law would let me offer my sworn oath, called wager of law, as conclusive proof that I did not owe the money. Doing so indicated both that I was willing to damn my soul to eternal hell by lying under oath, and that I could pay 11 other people, called oath helpers, to damn their souls by swearing they believed me. Only in the church courts could I be prosecuted for my breach of promise and made to do penance by paying the sum that I owed as the price of getting back into communion with the church. Rules like these gave the impression that early common law was devised for shrewd, savvy schemers who knew the rules and how to exploit them. Damn, that sounds like lawyers to me. Rules like these gave the impressions. Rules like these are why the courts are as fucked up as they are. Right? You don't know the procedure. The fools who trusted their neighbors to keep their promises, to act in good faith, and to do what was expected of them had to look outside the common law or wait a few centuries for the law to develop a new remedy like trespass on the case for assumption to rescue them. This impression of early common law resembles the bad man's view of the law put forward by Oliver Wendell Holmes in his speech, The Path of the Law, delivered in Boston University. The bad man would not see contracts as obligations to fulfill his promises, but only as options to either to perform as promised or to pay the damages a court of law would award. So the bad man is going to have an attorney who understands the procedures of the court. You're going to lose, they're going to win. You don't need to honor his contract. Early English criminal law also seemed out of step with the ordinary practice of trusting the fiduciary relationship. The common law, felonies of robbery and burglary were crimes committed by strangers with force and violence. Right? So in common law, robbery and burglary were done by strangers with force and violence, not by the guy sitting across the table from you that you know, because you were supposed to have had a fiduciary relationship with him. Right? It's only robbery and burglary if it was done by a stranger with force and violence. Otherwise, it wasn't a robbery and a burglary. It took several centuries for English law to extend felony liability to embezzlement, fraud, and forgery, acts in which wrongdoers were servants or agents of their victims or in transactions with their victims, and took advantage of the trust their victims reposed in them. Matters of substance of their common law were heavily influenced by procedural, jurisdictional, and evidentiary rules, and these examples from early contract criminal law are no exceptions. Matters of substance were influenced by procedural, jurisdictional, and evidentiary rules. If you didn't follow those, it doesn't matter what the substance is. They're going to say you didn't follow the rules. You lose. Can't win in a court of common law. Common law judges applied rules of pleading and procedure in a sharply adversarial setting, a battle of wits between rival advocates. One who pleaded badly could expect no mercy from the other side and none from the judge. But a lack of trust inside the medieval courtroom did not necessarily extend outward to the world outside of the courtroom, nor to the law applied outside of the courtroom. The medieval use. The common law annotation to notions of trust and fiduciary duty arose most prominently in the field of property law. The early common law had rigid rules of inheritance and feudal obligations. A dying landholder could not leave land by will to whoever he wanted, except in the city of London, and I think that's whose rules we're under today. Yada, yada, yada. If an heir of land in a high social level called knight service was under the age of 21, the feudal lord of the heir took the heir and land into wardship. Wardship permitted a lord to provide a reasonable maintenance for the heir to keep all profits from the heir's land until the heir turned 21. Wardship was thus a tremendous financial windfall for lords and otherwise were left on fixed feudal services. So basically the king, right, has all these people that work for him as knight's service, or however they work the thing out. And if you were the young son of somebody under knight's service who went to the Crusades and got killed, well, now the king gets to take the property of your father's estate until you're 21. And then maybe give it to you. But the lord collected these valuable rights only if the land was inherited from a dying tenant, not given away during his life. These feudal incidents, as they were called, of wardship and marriage, can be viewed as a tax. Oh, they also got to arrange your marriage for you. Within legal landscape starting in 1320, social practice developed that enabled landholders to avoid, a later king's lawyer would say evade, these feudal obligations. A landholder would transfer a bare legal title to a small group of persons who would hold that land in subordination to the same feudal lord for the benefit of the original landholder, and then for whoever the landholder would designate by will, thus circumventing the rule against wills of land. Right, so that way the property wouldn't go to the king and make your son his ward, allowing him to determine the marriage and so forth and so on and all this other crap, right? We're going to put it in somebody else's hands, the bare legal title, and they'll turn it over when the son reaches 21. This arrangement would delay transferring the land to the heir until he or she reached the age of 21, thus circumventing the feudal incident of wardship and marriage. Oh, a landholder could make provisions for daughters, young sons, and could take greater provisions for surviving spouse, as common law, dower, and courtesy afforded. He could also, by means of use, deprive a surviving spouse of those common law entitlements. Excuse me. If a landowner wanted to give land at his or her death to the church, this device also circumvented the statute of mortmain, enacted in 1279, that would have prohibited or required an expensive license from the king for such gifts of land. The standard terminology of this social practice was fiofment to uses. The landholder, or fioffer, that'd be the grantor, granted or enoffed the land to the fiofees, the trustees, to the use of the intended beneficiary, or the sesta que use. So sesta que use is the beneficiary. The feoffees, the trustees, nearly always at least 3 in number, would hold the land in joint tenancy with right of survivorship. This arrangement made it very unlikely that the legal title would descend from the last surviving trustee to that of the trustee's heir and give the lord a potential lordship. Because whoever has a legal title, if they die and the heir isn't over 21 years of age, right, then it's going to revert to the king as a lordship. Now, if they were doing this with people with, and normally I believe this was done with the church, and the guys in the church don't have any, shouldn't have any heirs. So, anyways, that's what a use was, just like a trust. The landholder granted to the trustee to the use of the beneficiary, who is called the cestui use. It was very common for the grantor to be the cestui use, the beneficiary. Similarly, in modern estate planning, settlers, the grantor, set up trusts during their lifetimes and are themselves the initial beneficiaries of the trust, keeping all the income from the trust property until their deaths and directing who next would receive the trust property after their deaths. Earlier legal historians suppose that uses were older than 1320s. Roots of the use and trust seem to have been proposed, a long time ago. But the medieval use seems to have been an English invention. Landholders tried various custodial arrangements in the 13th century. Uses were preceded by conditional grants, in which the terms of the feoffees, trustees' intent, such as the obligation to convey the land to the feoffer's heir after the heir reached 21, were spelled out as conditions of the title. See, they used to have all this stuff spelled out. However, such arrangements were caught by Chapter 6 of the Statute of Marlborough, enacted in 1276, which provided that feoffments intended to deprive the lord of their wardship were invalid, though feoffments made in good faith were valid. So what it looks like is you're gifting your property to the trustee, and then you're trusting that the trustee is going to do what you've asked them to do now that they have the legal title. So can you really trust the trustee? What set the use apart from these earlier arrangements was the separation of the legal title from the beneficial enjoyment of the land, the equitable title. Separated the title. Alienation by deed. Feoffees, the trustees to uses, had the full legal title to land and the right to sell or grant it and the ability to sue or be sued in relation to the land. The essential features of uses and allowed them to override the prohibition on wills of land, and that the beneficiary or the cestui use had no interest enforced by courts of common law and no remedy in courts of common law against the trustees who misbehaved. So at first, right, because in common law you weren't going to have a remedy. Well, yeah, we kind of like this now. We're going to find a way, those who like the common law because they're a bunch of crooks, we're going to find a way to steal your property. Uses developed in England and spread several decades, probably without any regular enforcement by the courts. The grantor set up such arrangements relying entirely on the goodwill of the trustee, who are bound only by personal ties of friendship to carry out the wishes of the grantor and at the grantor's death. But trustee did not always do as they were told. Go figure. Because beneficiaries had no protection at common law, the other courts stepped in to fill the gap. The first courts to do so were England's ecclesiastic courts. Church courts maintained a jurisdiction separate from the royal courts of common law. For instance, church courts had jurisdiction over wills of personal property, which were permissible throughout England, even though nearly all the land in England could not be devised by will. So you couldn't give your land away by will. By your will, I want to give this to this person and this to this person. You could do that with your personal property. Give my favorite chair to this person and the clock to your daughter or whatever it is. That's personal property. It was the land that you couldn't devise by will. Church courts supervise executors of wills, appointed administrators for personal property of estates, and arranged for guardians like orphan children. Church courts also dealt with a variety of trust-like arrangements in which land was held by one person for the benefit of another. Well, that sounds like the cesta que use. It sounds like the church was involved in the trust-like arrangements. Oh, no statute was passed. Okay, so excuse me. In 1402, the House of Commons prayed for remedy. I guess I probably need to read this whole thing. Has shown the trustees' obligation to uses were enforced in these church courts as early as 1375 and frequently in the first half of the 15th century, the 1400s. By 1460, however, such cases were disappeared from the church courts because the King's Courts of Chancery was enforcing such uses. In 1402, the House of Commons prayed for remedy, presumably by legislations against disloyal trustees who sold or raised money on lands instead of performing the wills of the grantor. But no statute was passed in response to this request. But the fact that it was made shows the practice of uses had become widespread, and the problem of lack of enforcement had risen to the attention of the king and parliament. The response came instead from the king's principal officers, the chancellor. Nearly all chancellors before 1530 were bishops or archbishops. They oversaw the royal writing office, which processed and issued for all common law courts. By 1380s, chancellors were also receiving and acting upon petitions that complained of beneficiaries' lack of remedies in courts of common law. Chancellors were receiving and acting upon complaints that trustees to uses were not acting in accordance with their instructions. Petitioners complained that the trustee disregarded the commands of their consciences by failing to carry out the deathbed intentions of the grantor who had given the title to their lands. It was not known how much of the chancery's business was taken up by enforcement of uses in the middle of the 15th century, but trustees who betrayed the grantor trust could be ordered by one of the king's principal officers to act in accordance with their conscience. In the chancellor's court, which came to be known as equity, trustee owed a fiduciary duty to carry out the grantor's wishes for the benefit of the beneficiary, the cesta que use. Attention to uses in the common law. In the common law, the fee office trustee had full legal title and the beneficiary had nothing. A standard illustration, right? So in common law, because the trustee has got the legal title, it's his property. Beneficiary doesn't have anything. There is no beneficiary. They don't see him. By the course of common law, the fee offerer had nothing more to do with the land than the greatest stranger in the world. Once he gave it away, the same justice also, this is 1502, the same Chief Justice said that in relation to fee offies, the trustee, by the course of common law, the fee offerer had nothing more to do with the land than the greatest strangers in the world. Once you gave it away to the trustee, you're screwed. This statement is an example of the extreme formalism of the early common law. Okay. Anyways, this goes on and on. I don't know how much more of this one I want to read. I want to get to the other stuff. But basically, this will tell you how we went from uses to trust. So let's get down to the Christopher St. Germain, a lawyer, wrote Doctor and Student, first published in 2 parts, to demonstrate that while the English law departed in some respects from the commands of conscience and other, right? English law departed in some respects from the commands of conscience. In other words, it's a law system for crooks. He wrote this book. It was a dialogue between a theologian and a lawyer, bringing out the rigor of the common law and a scope of sharp practice and manipulation. Right? You don't like the common law, man. It's a manipulated court system. Given that his topic was the real or apparent divergence between conscience and law, St. Germain also discussed fiatment of uses. In the voice of the lawyers, St. Germain wrote that generally every fiatment would be presumed to be a fiatment to the use of the grantor unless there had been a bargain or recompense or other expression of the grantor's intent to the benefit of the trustee. Unless there had been a bargain or recompense or other expression of the grantor's intent to benefit the... Okay. Basically, it was going to... The way the law saw it, the use was for the benefit of the grantor unless it specifically said it was for the benefit of the trustee. As the Justice of Common Pleas put it in 1522, common reason dictates that if I grant someone without consideration, it should be to my use. St. Germain explained that the grantor would have to sue in chancery for his remedy, and that in this respect the law applied by chancery accorded with conscience. And in 1481 case, Littleton advised the chancellor whether to enforce a use set up by an infant grantor. Now, how can an infant grant anything? That's interesting, right? This is law of infants coming up here. Littleton advised the chancellor whether to enforce a use set up by an infant grantor. The word trust is usually thought to have replaced the word use as the name of this landholder arrangement after 1536, with the statute of use was enacted. But lawyers and judges before 1500 used the word trust frequently referred to fiatment of uses. The word entered, yada yada yada. So the word trust, like a deed of trust, landholding arrangement. Right, and on a deed of trust, you put down the legal title to your property as collateral. And then you sign it. Put a seal on it. But they don't do anything. They just said, we'll file it for you. They go ahead and put it in their drawer. Now they're holding your promise that you gave them your property as a gift, because they haven't given you any consideration. So you must have meant it to be a gift for them. However, what this said, well, if they don't put down any consideration, then it was for the benefit of the beneficiary, and normally the beneficiary is seen to be the grantor. You want to get that down that rabbit hole. Okay, this latermost example also provides a glimpse of what would now be called fiduciary duties of these predecessors of our trustees as seen by judges of the common law court. Okay, then in 1468 the chancellor spoke of a fiatment and trust, and the justice of the common pleas described the duties of the trustee of a trust: to plead all pleas and to maintain an action for the land as the sestque use, the beneficiary, would want to plead, but this would be at the cost of the beneficiary. Justice Fitzgerald said that uses were at common law, and the use was nothing but a trust and confidence that he, the grantor, put a person of his trustee according to his estate, and that it was at common law. So when you get into this, now we're getting into the argument between Henry VIII and the justices, because a lot of the land in England had been put into these uses excuse me, and the king wasn't getting his wardships and his marriage ability to arrange marriages, which were all windfalls for him, and he wanted those back. And so they found a court case, because Henry's heavy-handed intervention in the legal disputes was perpetrated the notions of the common law was fundamentally opposed to uses and to notions of trust and fiduciary duty that accompanied them, right? The common law doesn't want to be held to anybody being responsible. It's just there for who's the better swindler. Okay, let's go on to this other one now. So, that's enough about the history of trust and uses and the dirty little secret of common law and why we really need to find equity. The ecclesiastic courts, so that we can get justice. Now, this is on the Michigan Constitution. It talks about the judicial power in courts of justice. The judicial power of the state is vested exclusively in one court of justice, which shall be divided into one Supreme Court, one Court of Appeals, one trial court of general jurisdiction known as the Circuit Court, one probate court. That's the constitutional courts. And courts of limited jurisdiction that the legislature may establish by 2/3 vote of members elected to and serving in each house. Those would be statutory courts, right? One set on top are the constitutional courts. The other ones the legislature can create, and those would be statutory courts. Overview of probate courts in Michigan. Introduction. Basis probate courts exclusive in concurrent jurisdiction. We're going to talk about a few things here. So, interesting. Here we go. Since probate court is a statutory court, whoa, hang on. Since probate court is a statutory court, I mean it's not a constitutional court. Proper case probate court is a statutory court. What that means is the court that you walk into that says probate court isn't the court we're looking for. It's a statutory court. It's not this probate court here, constitutional court. It's a court that was established by the legislature. It's a statutory court. The probate court you walk into and see the sign for is a statutory court. Can't make it any clearer. So it's not the constitutional probate court that they're talking about here. That's part of the one court of justice. This one probate court, constitutional court, is a different court than the probate court that's the statutory court. It's that simple. Historically, probate court jurisdiction is narrowly prescribed by Michigan jurisprudence, yada, yada, yada. In 1989, the legislature amended the revised probate code and gave probate court equitable jurisdiction. MCR 5.101 was amended to provide for the filing of a civil action in a probate court under certain limited circumstances. But again, we're not talking about the probate court with the sign. This is a different probate court. Probably has something to do with the county clerk. Could very well be. Tom and Rich, you need to find out. When that attorney took the paperwork for Rich's court case, and he only submitted 2 pieces of paper, guys. One went to the circuit court clerk, one went to the county clerk. What's the one that went to the county clerk? Really need to know. Probate court has exclusive jurisdiction to settle accounts of all fiduciaries. Now, there's probate court, uppercase. That's that probate court. That probate court has exclusive jurisdiction to settle accounts of all fiduciaries, apparently. But see, this court here, now because probate starts the sentence, the P is capitalized, but this probate court under decedent's estate is not the same as this probate court here, and probably not the same as this probate court here. This is the statutory, this is the constitutional, and because it starts the sentence, the P is capitalized. The Constitutional Probate Court have exclusive legal and equitable jurisdiction over matters relating to settlement of deceased persons' estates. Again, the Constitutional Probate Courts have exclusive legal equitable jurisdiction over proceedings concerning the validity of trust. And here's all the things they can do. Probate courts, right? Again, just because it's capitalized, this probate court is the constitutional court. This probate court, the one you walk into, is the statutory court. We want this probate court, lowercase, and because we're starting some sentences with it, the P's been capitalized, but the court isn't. So this again is the constitutional court. It's not the one that says probate when you walk in the frickin' court building. Probate, right? Probate has exclusive jurisdiction to review and settle fiduciary accounts. Okay, well that's good. Probate courts have exclusive jurisdiction over proceedings concerning conservatorship, guardianship. They have concurrent jurisdiction, legal and equitable jurisdiction over the following matters involved: estate of decedent. Now, what's a decedent? Decedent's just somebody who hasn't been heard from for 5 to 7 years. Protected individuals, trust, or ward. They get to determine property, rights, and interest. Again, this is the constitutional probate court, not the probate court with the sign above the door. We got to figure out who that is. Contract disputes, by or against an estate, ward, or trust. Right, and so this contract dispute here, by or against an estate, ward, or trust, has to do with your foreclosure. To authorize specific performance of a contract in a joint or mutual will, or of a contract to leave property by will. There's another one. That one has to do with your foreclosure. Does not confer upon a fiduciary any absolute right to bring whatever type of civil action they may desire to probate court. Okay, they can't bring all different kinds, but they can bring some. Right, so I'll let you read it. Again, I'll send this along, but you could read this stuff yourself if you download the paperwork. But here's some interesting. So now we got a Michigan compiled law. Apparently gives probate court the ability to utilize execution to enforce its judgments. Whenever a judgment is rendered by any court, execution to collect the same may be issued to the sheriff, bailiff, or other proper officer. So this probate court that we don't really see has got a shitload of frickin' power. Chapter 3 of the Michigan Court Rules deals with special proceedings. Rules in this chapter apply to circuit court and other courts as provided by law or by these rules. Probate court. Okay. So Michigan Court Rule 5.101, in order to furnish additional guidance on the question of probate constitutional court jurisdiction, was amended. And this is how it reads now. Form of action. There are two forms of action, a proceeding and a civil action in the constitutional probate court. A proceeding is commenced by filing an application or a petition. That's a proceeding. A civil action is started by filing a complaint. A complaint filed by a claimant. The following actions must be titled civil actions commenced by filing a complaint and governed by the rules which the applicant to the civil action in circuit court. Right? So in the probate court, you can't see. They can open up a civil action against you by filing a complaint. Any complaint against another filed by a fiduciary. So, who's the fiduciary? The fiduciary is the one who's supposed to have done something with this trust. And they're the ones filing a complaint. Who can they file a complaint for? Well, they can the grantee, if you remember from the other one, the trustee can file a complaint for the cesta K use as long as the cesta K use pays the bill. Cesta K use being the beneficiary. a complaint filed by a claimant after notice that the claim has been disallowed. Two different ways that they could file a civil action in a probate court. Civil actions are used for problems with contracts. Michigan court rule provides a procedure in probate court. The constitutional court is governed by the rules applicable to other civil proceedings, except as modified by the probate rules. Civil proceedings. They mean inquisitorial instead of common law, adversarial. History of the probate court. Before the Norman Conquest, there was no separate ecclesiastic courts in England. The clergy took part in proceedings in secular courts. William the Conqueror separated the ecclesiastic courts from the secular courts. In a field of probate, the result was the ecclesiastic courts ultimately acquired jurisdiction of succession to personality, personal property, including testamentary succession, while the secular courts retained jurisdiction of succession of freehold interest and realty, including jurisdiction over wills. But they were talking about willing your property, your land. Testament, something that serves as tangible proof or evidence. Piece of paper saying that this is what we're going to do. The common law took little interest in the goods of persons, which are far less public importance than land. The church had a definite interest in the goods of persons. The religious belief that time required at least the party of his property to devote it to good of his soul, and he made a will, was almost certain he would make provisions for the saying of masses. If he neglected to make a will, and in the 12th, 13th centuries it was regarded as almost a sin to die without making one, the church would make provisions which he had failed to make for his soul. The church court assumed jurisdiction over the dead man's goods, and they'd go ahead and take a cut. The jurisdiction of the ecclesiastic courts placed the development of the laws of testament in the hands of men who knew more about canon law and Roman law than common law, and accordingly the law of testaments was borrowed in part from the Roman law, which is civil procedures. Inquisitorial, not accusatorial. Like the lay courts, the ecclesiastic courts were organized in graduated hierarchy. Yeah, you got boom, boom, boom. Got court of first instance, second instance, third instance. Had different names back then. The medieval system of ecclesiastic courts was not much affected by the Reformation, except since the power of the state had been replaced the power of Rome. So now there is no separation of church and state. The ultimate right of appeal, the papal curia, was naturally disappeared. In its place, a court of delegates was established to hear appeals for decisions of the provincial courts. And that new court was composed of royal commissioners. The law which is administered in the ecclesiastic courts was canon church law, and many of its principles were derived from the civil Roman law. Hence, the lawyers who practiced it were not ordinary barristers, but civilians or doctors. So if you find somebody who's a doctor, they're a doctor of law, they're working in ecclesiastic law, not common law. In the Middle Ages, the ecclesiastic judge had to be in orders and over 25 years of age. He was not necessarily a priest, but might have been in minor orders. He was appointed by commission either for a limited period or during the bishop's pleasure. Let's look at something real fast here. Now, here's a clerk. First of all, it's all the same as clericus or cleric. In English ecclesiastic law, a priest or clergyman, a person in orders. When a person has been ordained a priest, he is, in the language of the law, a clerk in orders. A person presented to a benefice or living is technically called a clerk. In general law practice, an officer of the court who keeps its minutes and records of proceedings as the custody of his record and a seal, sometimes called a proto-notary. See clerkship. This later meaning of the term clerk, which is prevalent one in our modern law, though itself considerable antiquity, seems to have been entirely grown out of the primitive signification of ecclesiastic. They're ecclesiastics. Clericus. In the Roman law, a minister of religion in the Christian church, an ecclesiastic, a priest. A general term including bishops, priests, deacons, and other inferior orders. In the Code of Justinian, however, bishops were named distinctly were named distinctly from clerici. In feudal law, the term occurs in the same sense. So in either way, in feudal law, Roman law, it's a minister of the Christian church. The clerks are working for the church. A clergyman, a clerk, a priest, a person of holy orders. There is no clerk that is not an advocate. That's good. There is no clerk that is not an advocate. Appoint him your advocate. Go in there and appoint the clerk your advocate and say, you're working for the bishop, I appoint you my advocate, they're stealing my property, you got to do something about it. Yeah, we'll work on the words, but you get the idea. Alright. Every ecclesiastic judge could appoint a deputy known as a surrogate to keep court for him in his absence. Under Canon 128, I don't know what that is, but I believe Canon 128, now we're talking Episcopal or Anglican canon law. The surrogate had to be a grave minister. WTF is a grave minister? Is that the guy that's over the cemeteries? That would be interesting, because I know the cemeteries has something to do with this. You know, anybody who's died that we think is dead, right? They're only considered decedents because we've not taken the death certificate to the proper office, which is going to end up being this proper probate court, to give it to them. We're all considered decedents. We here today haven't been heard from for 5 to 7 years. We're a decedent. If your parents or grandparents have passed away, chances are they're still decedents because you haven't taken the frickin' death certificate to the proper office to have it recorded. It's not gone to the right probate court. And so you haven't gotten your inheritance. And your inheritance is everything that isn't given away by will. So they had to be a grave minister and a graduate, a licensed public preacher, or a bachelor of law. Those were what this surrogate could be, and I think the surrogate then became the register. So now we're getting good. In the 17th century, registrars began to be appointed for life under letters patent from the bishop. On appointment, they took the same oath and made the same declarations as prescribed for ecclesiastic judges. That means the registrars are the ecclesiastic judges. Right? They're taking the same oath and the same declaration as prescribed for ecclesiastic judges. The registrar is the ecclesiastic judge. In the course of time, as power of the state grew and the power of the church in England diminished, the ecclesiastic courts lost much of their ancient jurisdiction. The net result was that Chancery, with its more flexible procedure, tended more and more to take over matters of administration. So they're taking over the administration, not the judicial, the administrative, the executive, the paperwork end. Though the will would be admitted to probate, so the will went to probate, right? The constitutional probate court. And they were appointed by the ecclesiastic court, so they were appointed then by the registrar. The rest of it, once that's happened, then it went to Chancery to be administered, executed. The jurisdiction might be sought for the purposes to govern assets. Trust was involved, though no actual trust was involved because the estate was regarded as a kind of trust fund, the personal representatives as a kind of trustee. Now, can't pay attention to this, right? Because there is actually no trust. It just kind of looks like one. And it kind of looks like we were given a guardian, and now we have conservators, and they're kind of like the trustee. Right? So to me, there is no trust. To have a trust, the trustee and grantor have to both sign a trust agreement. Otherwise, with only your signature, it is a unilateral contract, good only for a gift or donation, and only if lawfully done, as in your intention to gift your home to a stranger. Right? Was that your intention? You wanted to give it to a stranger? Chancery never assumed jurisdiction to probate a will or to appoint an executor or administrator. That is done by the Constitutional Probate Court. The Constitutional Probate Court is an ecclesiastic court. The ecclesiastic judge of that ecclesiastic court is the who? The registrar. In the 17th century, registrars began to be appointed for life under letters patent from the bishop. On appointment, they took the same oath and made the same declarations as prescribed for ecclesiastic judges. That's where it starts, with whoever they're considering this registrar to be. Now, I'm going to say it could still be the county clerk. Right? Because clerks are clerics. So you could ask your probate registrar who the judge of the ecclesiastic court is. If they confess and avoid away, tell them when you lie, it's not to the man, it's to God, and that you are taking their testimony for God. So ask them again. In 1857, the probate matrimonial jurisdiction of ecclesiastic courts was conferred to the Court of Probate and Divorce Court. Yeah, so they keep playing with stuff. A lot of this has to do with England, obviously. Okay. In 1925, a High Court of Justice was created consisting of 3 divisions. The Chancery, the King's Bench, the Probate, Divorce, and Amity Division. Lumping together of these 3 topics is often a source of wonder or amusement. Sir Alan Herbert has suggested that the idea of its jurisdiction over wrecks of wills, marriages, and ships. Very early colonial times, testimony jurisdiction was commonly given to general courts or vested in governors and their councils. Somewhat later, probate jurisdiction was added to the county or other trial courts. Congress then enacted the Ordinance of 1787, setting up Northwest Territory. The Ordinance, second of its Articles of Compact, provided all inhabitants shall always be entitled to. Now here's where they're going to pork you again, man, to get ready for the, where's the Vaseline? Shall always be entitled to judicial proceedings according to the course of common law. You don't want to have proceedings by the course of common law. You're going to get screwed. You don't know what the procedure is. Shall always be entitled to. Tell him you don't want it. I'm not entitled to judicial proceedings according to the course of common law. No, I want equity. A court of probate and surrogate court were established in 17, and according to recording acts for deeds, wills, and other important instruments, was passed in 1818. I think we're talking about Illinois here now. Adopted bodily. Yeah, they took the laws of Massachusetts and they made them their own laws. The laws originating in Massachusetts thus became and still constitute this is for Wisconsin, the basic jurisdiction and procedure in the county courts of Wisconsin. Right? So the county courts in Wisconsin are the probate courts. Of other courts of record related to civil jurisdiction, some of the county courts, this legislative treatment of the county courts was as a court of probate. Right? So, county court, court of probate. Although the probate courts derive historically from ecclesiastic courts, there we go again, our county courts having jurisdiction to matters in probate formerly exercised by courts of chancery and common law. It's because their jurisdiction is different and wider, right? Our county courts having jurisdiction in matters of probate formerly exercised by courts of chancery and common law. Now, I don't know you're going to see this county court again. You're not going to walk in and see a sign that says county court. Under court reorganization, the probate jurisdiction is retained in the county courts of the state. County court, county court, county court. And then 5. The above article, right? So when you go through these things, right, I take a lot of them out, but you'll have the footnotes that take you to the bottom. So this was footnote number 5. The judge sitting in these branches exercises the constitutional probate powers of the probate court. Under the Act, the registrars in probate remain the right hand of the judge of probate branches of the county courts. The above article was prepared from the following additional sources: The Ecclesiastic Courts, Principles of Reconstruction. The report of the commissions of the ecclesiastic courts set up by the Archbishop of Canterbury and York in 1951 at the request of the convocations. We're talking about Wisconsin. And in Wisconsin, the way the shit was set up was based on what the frickin' Commission of Ecclesiastic Courts set up by the Archbishop of Canterbury and York said in 1951. It seems the Queen is still involved in our affairs via the Episcopal Church. There is no separation of church and state within the realms of England. And we're still there. Okay, this is that little thing on the bishop. Probate courts in Georgia are courts of limited or special jurisdiction. 159 counties in Georgia have one probate court and one probate judge. The probate judge is elected constitutional county officer with a 4-year term of office. The probate judge is successor to the position originally known as the ordinary. Before the creation of the board's commission, which today govern the affairs of the county, the ordinary was the chief administrative officer. So the ordinary used to be the chief administrative officer, but now they've given that shit up to the board. Doesn't mean he's not the judge, he just gave away the administration. The ordinary has all the powers of government. He's the executive, legislative, and judicial branch all wrapped up into one. And they're all his powers. He just delegates them out. Of the county and ran the county's business. Many of the administrator's duties and functions of the probate court derive from that fact, okay? Each probate judge is a member of the Council of Probate Court Judges of Georgia, created in 1988 to further the improvement, right? So that's where they all get together someplace. I bet you they get together, and guess who's sitting there with them? The head nut bishop over the whole state. The council receives assistance in performance of its duties from administrative office of the courts. Handbook. Might be good to get this handbook. Handbook Probate Judges of Georgia, Georgia Probate Bench Book, yada yada yada. The probate court has exclusive original jurisdiction over certain categories of cases involving decedents, estates, adult guardianship, minor guardianship, involuntary treatment of persons suffering mental health. Again, this is the constitutional probate court, which isn't the one that you're necessarily going to walk into. Probate courts perform other judicial, administrative, and ministerial functions. Additional functions, right? The probate courts perform other judicial and ministerial functions, including but not limited to maintenance and upkeep of public records and minutes of proceedings in a court, acceptance of maintenance of funds, as custodian for missing heirs or minors without conservators. All right, there's your custodian for missing heirs. You're missing. Go tell her you showed up. Issuance of marriage licenses, issuance of firearms permits, issuance of residency certificates. Not that you're a resident, your residency certificate. Right, that would show that you're alive. Issuance of license to conduct business for veterans. Issues permits to perform public fireworks. Filling vacancies for certain public offices. Administering oaths of public officials. Acceptance, approval of recording of bonds of certain public officials. It sounds like the frickin' clerk to me. This is shit the county clerk does in Michigan. Right? In Georgia, who does this? Forget the name probate. Who does these things? Whoever does this shit is the probate judge. Probate courts also may hear cases involving the removal or obstruction of roads. Together with the sheriff and clerk of the Superior Court, probate judges designate the official legal organ, the newspaper in which legal advertisements are published. Now this is important. They pick a newspaper, the official legal organ. If you're going to put something in and think that it's going to be public notice, it had better be the official legal organ. But the great thing is this means the sheriff and the clerk of the Superior Court know who the probate judge is. The one that helped them determine the official legal organ. In counties in which there is no state court, the probate judge hears all traffic and game and fish violation cases. Right? Well, I think the way things are now, that there are no state courts. They've all been usurped. There's nobody holding a state office. Except maybe the probate judge. He hears all the traffic cases, right? Go ask the traffic judge if he's the frickin' if he's the constitutional probate judge. Accept his oath, bind it to her, remember he has a fiduciary duty, and you're taking his testimony for God Almighty. Probate courts also have concurrent jurisdiction to hear certain other misdemeanor cases. Yes, yes, yes. Maybe like your foreclosure. All right, you wouldn't be in court except someone is saying you broke a law, be it tort or breach of contract, whatever. It's a misdemeanor. It's the probate court where the action is started. Then they get you going into the administrative court, the other end of the court, right? You never answered the original complaint against you, and eventually you lose because you didn't go to the bishop to tell him. You have to answer the charge by going to the bishop, the ordinary probate judge in Georgia, and telling him or her under oath that the plaintiff did not lend me any money, so help me God. I think you could tell him that. In certain counties, the probate judge also serves as the chief magistrate for the county, the head man, and as such oversees the operation and hears cases in the magistrate court. Well, isn't the magistrate court where traffic is? Isn't that where traffic court is? I think it would be. Chief magistrate, he's a big dog. Should be. In certain counties, the probate court serves as the vital records. Come on, man, this is county clerk stuff in Michigan. Vital records custodian for the county, maintaining and issuing certified copies of birth and death records within the county. Duh, it's county clerk. In certain counties, or at least the county clerk is working for this guy, right? Again, that could be the administrative end that you see. That's the administration. But what's behind the curtain? The probate judge. This court was given the authority to grant probate of wills, letters of administration, sole jurisdiction of courts, and chancery suits and legacies. Okay, I think we went into a new one here. It is to be seen, therefore, that by the time of the American Revolution, the exclusive authority of the church courts had become little more than ministerial in nature. By the time the American civil law, their jurisdiction had been abolished, and a new court called Court of Probate was established. The court was given the authority to grant probate, wills, letters of administration by enacting statutes left to the sole jurisdiction of courts, and chancery suits for legacy, suits for distribution. There is no one American system of probate. A general pattern may be seen by probate law and practice in the United States must, in the main, be studied in reference to the judicial system and code of each particular state. Therefore, the national development of the subject is traced to the broadest terms and within the understanding of each of the such generalities as may be subject to the minute qualifications. I'm getting tired of talking. This thing must be getting kind of long. In this one fundamental, however, all states are identical. Their judicial systems are, in outline at least, established by the respective constitutions. Right? So in Michigan, you got one court of justice. It's got the Supreme Court, Court of Appeals, Court of General Jurisdiction, and a probate court. And then inferior courts. But the constitutional provisions vary greatly. Yeah. In their powers were combined not only those of the spiritual courts of England, the ecclesiastic courts, but also the powers possessed by the English common law and chancery courts, insofar as such powers were necessary to control the administration. Okay, so a chief distinction, albeit improvement in American probate courts as compared to English, was the instance of American courts were invested with necessary jurisdiction and authority to supervise completely the administration of decedents' estates. So, in their powers were combined not only those of the ecclesiastic court, but those of the common law and chancery. So the probate court, constitutional probate court, is a powerful court. The first probate courts were established in the country after the Revolutionary War. Probate jurisdiction was vested in the general county courts. Today, in the more sparsely settled states, or even in thinly populated sections of some of the more populous states, probate functions are exercised by the county or parish tribunals. As population grew, however, it became necessary to divide the work of the courts, and new courts were created for the transaction of such business as somewhat pertain to estates of dead, guardianship, minors, and competent persons. So they took a part of the probate business and they put it in the probate court that you think of every day. They didn't give it all to them. They just established some new courts and gave them part of it. But it still starts in the other probate court. Right? This is the transaction of business. This is the administrative end. But the judicial end still happens in the probate court, which is the county court. Moreover, in many states, there has also been delegated to these courts supervision of testamentary trust, a jurisdiction historically and factually within the realm of equity jurisprudence. These courts are called orphans courts, surrogates, prerogative, and probate courts. Right? So those are all the new courts that were established outside of the county court that has the power. Probate jurisdiction in the United States were exercised in simplicity. Cost fees are relatively low. Mode of procedure is ordinarily by simple petition, which states the few facts necessary to give the court jurisdiction. Because now Roe just went and had some things recorded at the county clerk's office. 50 cents a page, 50 cents an item to have it recorded. I'd say that's relatively cheap. Right? By simple petition, by filling out a piece of paper saying you want to do this, right, gives the court the jurisdiction, costs her 50 cents to have whatever it was done. That included having her baptismal certificate recorded, her warranty deed recorded. I don't remember what the other two things were. I have to talk to her about it again. The procedure is in rem and not in partes between the parties among the various claimants. So the jurisdiction of the persons of such claimants is unnecessary. It's just about the property. The res is the estate of the decedent. And again, a decedent doesn't mean you have to be dead. You just haven't been seen. In whose name and on behalf of those estates proceedings have become needful. Both realty and personality are subject to the probate jurisdiction. Eventually they added realty to the probate jurisdiction. At first it just started out as personality, personal property. Eventually they got the realty in there, real property. Because I think now we're just trading pieces of paper anyways. Nobody actually owns the land. The land is held in trust. And all you can ever get is a copyhold estate saying that you have use of this property for as long as you want to use it. You can give it to your kids. You can do whatever you want to it. If you ever decide to leave it for more than 6 months, it's going to be considered abandoned, and it can be given to somebody else. That way it's not wasted. So, I'm getting tired. I'm not going to read the rest of all this stuff anymore. Here we go again. And to the inhabitants was warranted the benefits of judicial proceedings according to the course of the common law. What a screwing that was, man. That is not to your benefit. You don't want anything to do with the judicial proceedings at the course of common law because you have no idea what they are. A court was appointed consisting of 3 judges who were to have common law jurisdiction, and to the inhabitants was warranted the benefits of judicial proceedings according to the course of common law. Thank you, no. The governor and judges acted more than 25 laws, but since they were not adopted from the laws of the original states, it seems they may have done something wrong. Yeah, when they first came in, when this is to do with the Northwest Ordinance, when the judge and the 3 governors came into this big ass territory called the Northwest Ordinance, which, 5 or 6 states, I think it was 5 states, that's all there is. They come in and they're supposed to, if they're going to enact a law, take one from a state that's already been, right, from a state law. Well, they didn't do that. They just wrote their own laws. They were not adopted from the laws of original states. Included in the laws of 1788 was one establishing a court of probate, 1 judge to be appointed in each county. Go figure. Not done by the law, or not done within their mandate. commission that they were given when they took over the government of the territory. Whose duty it shall be to take proof of last wills and testaments and grant letters testamentary, letters of administration, and to do and perform every matter of thing that doth or by law may appertain to probate office, excepting the rendering definitive sentence and final decrees. Okay, then they did an orphans court, right, to take over some of the stuff to do with orphans, probate of wills, so forth and so on. But not the one thing that's really important. Not where the shit starts. Constitution 1848. There was to be in each county a court to be called the county court. The jurisdiction was to extend to all probate and such other jurisdiction as General Assembly may confer in civil cases. The clerk of the courts were to perform all the ministerial duties theretofore performed by the probate court, but the following were to be considered the general judicial powers, granting of letters testamentary. But the following were considered to be as general judicial powers, granting of letters testamentary or letters of administration, except to collect and repealing the same, allowing or disallowing claims, determining who was entitled to letters, requiring the settlement of an estate. Right? So these are the things a clerk could do, except they really couldn't grant the letters testamentary or letters of administration. However, in 1851, the county clerk was given power to grant these letters and citations. Well, that's a traffic ticket, while the court was not in session, subject to the approval or disapproval of the court at its next term. Well, okay, the court doesn't necessarily have to be in session all that often. Show up once a month, do the paperwork. Up until then, the clerk is going to do all the paperwork, take it into court, and then get the judge to sign off on it. And this was in modern times up to 1940, right? And again, they still had county courts, because this goes to show that they keep changing constitutions. Like Michigan, we probably had four constitutions since 1836. All right, we keep changing the Constitution. So this one was changed again, and this is the one of 1870. Again, this is Illinois. The county court shall be courts of record, shall have original jurisdiction in all matters of probate. That didn't change. All right, they gave them all these powers. The General Assembly may provide for establishment of a probate court, and each court having a population over 50,000. Right, they may do that. And for the election of a judge, they may do all these things. Said courts, when established, shall have original jurisdiction of all probate matters. They will have original, but not exclusive original, as we'll see here in a little bit. Thus, probate jurisdiction was continued in the county courts, but legislation was empowered to create and establish a distinctive probate. And then they said in 1877, more than 100,000 probate court. County courts and counties would be established, were directed to turn over their probate court, all probate records, files, and papers. Therefore, were established the probate courts to take over exclusively the probate functions of the county court. The act was amended in 1881. This revision of the statutes in 1874, county courts were given probate jurisdiction, similar to that later given to the probate courts by the Act of 1877, with one most important distinction. In defining the jurisdiction of the county courts, the constitutional provisions included such other jurisdiction as may be provided for by general law, which also included in the statute. So they may have given away some probate stuff, but they didn't give away everything. Appearing as this provision does in the Constitution and the statutes, seems always to be a possibility that the legislature could, if it so desired, confer upon the county courts probate jurisdiction and powers that it cannot confer upon probate courts. It can give them more powers and probate jurisdiction. It would seem possible, therefore, subject to constitutional limitations, for the legislature to complete an anomalous condition wherein county court, in the exercise of their probate functions, could have broader powers and jurisdiction than the probate courts. Could have all the powers of probate and more, even though we have probate courts. Go figure. However, this added jurisdictional provision for county courts appears not to have been utilized, and thus it seems that under the laws that exist, the probate powers and jurisdiction of the county court, which powers are existent only in those counties which have no probate court, are identical with the powers and jurisdiction of the probate courts. However, not without some hesitation is this statement ventured. But if it had been taken as recital of what the legislature had done in conferring jurisdiction, and not as to what it is within the power of the legislature to do, it is believed to represent true and proper statement of the present relative powers and jurisdictions of the two courts and exercise probate functions within their respective spheres. In other words, this guy doesn't know what the hell they did. He's leaving himself an opening because, in my opinion, the county court still has all this power no matter how much they try to make it sound like they don't. They do. And who's over the county court? Well, somehow the county clerk is definitely a part of it. Okay, so the three branches of ecclesiastic jurisdiction of probate, those haven't gone away yet, right? Ecclesiastic jurisdiction, it's still there. The ecclesiastic jurisdiction of wills, of granting of the administration, of suing for legacies, yada yada yada, right? There's three. Of the classes of jurisdictional limited to probate courts by the Constitution, this paper is concerned with only three. All probate matters, the settlement of estates of deceased persons and the sale of real estate of deceased persons for the payment of debts. The first two of these, at least, are of wide extent. They encompass and much more than was embodied in the three branches of the ecclesiastic jurisdiction of probate, of wills. And the sale of real estate to pay debts is a subject which has never been within the purview of English courts of probate, either ecclesiastic or civil. It's just something we did here in America. The further purpose of this paper is to explore the questions and the details in the administration of estates within these three constitutional ecclesiastic limitations. And this is from one of the read between the lines things there. One delegate sought to change this to exclusive original jurisdiction, but it was amended to original jurisdiction on the argument of Mr. Hay, in which he stated, there are many instances in which the Court of Chancery has necessary concurrent jurisdiction with probate courts in matters of probate which would be effectually cut off by the use of this language. It is well known that there are many cases in which the settlement of an estate becomes complicated with equitable and conflicting questions that cannot be adjudicated in the county court, and it becomes necessary to resort to settlement of these questions questions in the court of equity. That's why when they said they're going to create these probate courts, okay, so that makes the Court of Chancery sound like, well, the ecclesiastic court at least is the county clerk, county court. Debates and proceedings of constitutional conventions. Only the final draft contained the phrase concerning the sale of real estate to pay debts, because that had never been around before. Didn't ever do it in England. By amendment and convention, it was added. The reason stated being the desirability in counties of size as to require a probate court, that all questions relating to the estates of deceased persons shall be settled therein, and that it would only place the probate court on that point on the same level with county courts in the exercise of probate jurisdiction given to them. This reason is somewhat inconsistent with the argument described in Note 94, which it would have been more apt if the delegate had suggested as many questions as possible should be settled in the probate court. Anyways, somehow they slipped in the fact that we're going to take your property as part of probate. But that probate, I don't believe, is happening in the probate court. It's happening in the statutory probate court. So, anywho, what did we get about all this? Well, here's a big thing to me, is that, at least in Michigan, we have a constitutional probate court, and we also have a statutory probate court. Because it says right here, since probate court, where probate and court are both capitalized, is a statutory court, compared to probate court, uncapitalized, which is the constitutional court. That's stuff to be examined further in the week. Okay, that's all I got for today. Y'all hope it was worth something to you, and go ask some questions. We know now that the registrar could have taken the same oath and declaration as an ecclesiastic judge. If they did, that's very, very important. Who is that person? So, let's see what this week brings. See ya. Take care. Bye.